I have sentenced violent offenders. I have removed screaming litigants. I have watched people destroy their own cases in less than a minute. But in all my years on the bench, nothing prepared me for the woman who stood in my courtroom, pointed at me, and announced that I was under citizen's arrest. Believe me, even the bailiff thought he had misheard her. Her name was Karen Whitmore, and the moment she entered my courtroom, I sensed trouble. Not ordinary trouble. The kind of trouble that arrives, convinced it is the smartest person in the room. Years on the bench teach you to recognize confidence. They also teach you to recognize delusion. The two can look very similar from a distance. Karen wore a cream-colored blazer, expensive jewelry, and an expression that suggested she was not attending court. She was attending a coronation. Her own, across from her, stood Michael Turner, a local contractor in his late 50s. His case was straightforward, or at least it should have been. Michael claimed Karen hired him to renovate a luxury outdoor patio, approved the work, then refused to pay the final invoice after the project was completed. Karen claimed Michael committed fraud. On paper, it looked like a standard payment dispute, but before the hearing even officially began, Karen had already interrupted court staff twice, argued with the clerk about procedure, and demanded to know whether I had personally reviewed every document in her file. That last question interested me, not because it was unusual, because of how she asked it. She was not seeking information. She was searching for weakness. Some people enter court hoping to be heard. Others enter hoping to find a crack in the system they can exploit. Karen belonged to the second category. I asked Michael to explain the agreement. He calmly submitted signed contracts, change orders, photographs, and payment records. Karen immediately laughed, not nervously, dismissively. That laugh echoed through the room. The gallery shifted. Michael looked down, and I made my first observation of the day. Karen was not responding to evidence. She was responding to attention. There is a difference. Attention seekers perform for reactions. Truth seekers focus on facts. Karen wanted reactions. Then she stood, without permission. She held up a thick binder full of papers covered in colored tabs. "Your Honor," she announced, "before this fraudulent proceeding continues, there are serious legal issues that must be addressed." The room became quiet. I nodded. "Proceed." Karen smiled, a smile that suggested she had rehearsed this moment. She opened her binder dramatically and began citing legal terms: jurisdiction, due process, misconduct, constitutional violations, conflict of interest. Most of the phrases were being used incorrectly, but Karen delivered them with such confidence that someone unfamiliar with the law might have been impressed. That is the danger of false expertise. It often sounds convincing to people who do not know better. I listened patiently, then I asked a simple question. "Which specific action by this court violated your rights?" Karen froze. Only briefly, but I saw it. Because people who truly understand an argument answer directly. People performing an argument usually need time to invent one. Then she pointed toward me. "Your entire conduct." The gallery murmured. Michael rubbed his forehead. The bailiff crossed his arms. And I realized this case was about to become far stranger than a patio renovation dispute, because Karen had not come to defend herself. She had come to challenge the existence of the courtroom itself. And she was only getting started. When Karen Whitmore said my entire conduct violated her rights, the courtroom became unusually quiet, not because anyone believed her, because everyone was waiting to see where she would go next. Years on the bench teach you that people reveal themselves under pressure. Some become emotional. Some become defensive. Some become honest. Karen became theatrical. She flipped through her binder with exaggerated confidence, pulling out highlighted pages and printed articles she had clearly gathered from various websites. "Your Honor," she announced, "I have spent weeks researching the law." That sentence is rarely as impressive as people think it is. Research can be valuable, but research without understanding is like carrying a toolbox without knowing how to use the tools, Karen continued. "I have discovered multiple procedural violations in this court." I asked, "Such as?" She pointed at me dramatically. "You failed to establish lawful authority." The gallery exchanged confused looks. Michael Turner blinked twice. Even the court reporter paused for a moment before continuing. I said, "Mrs. Whitmore, this is a duly authorized court proceeding." She shook her head. "No, authority must be proven." That statement explained everything. Karen was not here to discuss a construction contract anymore. She was following a script. A script she likely believed would give her power over a system she did not understand. Michael's attorney attempted to redirect the hearing back to the actual dispute. He submitted sign change orders showing Karen approved upgraded stonework, custom lighting, and additional drainage installation. Karen barely looked at them. That fascinated me because innocent people usually want evidence examined. Karen wanted evidence ignored. Every document that brought the conversation back to reality was an obstacle to her performance. Then Michael's attorney showed photographs of the completed patio. The work looked professional, clean, finished, exactly as specified. Karen immediately objected. Those photographs are irrelevant, I asked. How are photographs of the completed project irrelevant to a payment dispute? She responded without hesitation. Because this court lacks jurisdiction. Again. Jurisdiction. The word had become her shield. Every time facts approached, she hid behind it. That pattern matters. People often reveal their weakest point by what they repeatedly avoid. Karen was avoiding the contract, the invoices. The approvals, the payments, everything. Then Michael testified that Karen stopped responding to calls immediately after the project was completed. He said she had praised the work repeatedly during construction. Karen interrupted. That is hearsay. It wasn't. But she said it confidently. Confidence is a dangerous thing when it becomes disconnected from truth. I calmly explained why the testimony was admissible. Karen shook her head. You are making legal errors. The gallery remained silent. At this point, even the spectators seemed fascinated, not by the case, by Karen, because everyone could see the same thing happening. The more evidence appeared, the less she talked about the patio. And then something interesting happened. Michael's attorney submitted a text message exchange. Karen had written, "The patio looks amazing." Another message, "Best investment I've made all year." Another, "My neighbors are jealous." The courtroom became still. Karen stared at the screen. Then she said something that immediately caught my attention. I was under coercion when I sent those. Under coercion, 3 separate messages, weeks apart, sent from her phone. Praising the work. According to Karen, all of them were somehow coerced. I leaned back and studied her, because at that moment, I stopped thinking about the contract dispute. I started thinking about behavior. People willing to deny obvious facts often become dangerous when cornered. Not physically dangerous, but unpredictably desperate. Then Karen reached into her binder again. This time she removed a document she had not shown earlier. Her face brightened. For the first time all morning, she looked genuinely excited. That worried me because people like Karen become most confident right before making their worst decision. She raised the document above her head and said, "Good. Now we can discuss your criminal liability." And suddenly the courtroom wasn't dealing with a contractor dispute anymore. The moment Karen Whitmore said, "Now we can discuss your criminal liability," every person in the courtroom looked at her. Not at me, at her, because even the spectators understood something important. A contractor payment dispute does not suddenly become a criminal case against the judge. Yet Karen looked delighted. That concerned me. People who become excited when reality falls apart are often preparing to replace reality with something else. I asked calmly, "Mrs. Whitmore, what criminal liability are you referring to?" She held up the document like a trophy. "This." I waited. She seemed surprised I wasn't reacting. Then she announced, "I have prepared a formal affidavit documenting judicial misconduct." The gallery exchanged looks. Michael Turner slowly lowered his head into one hand. The bailiff remained motionless. Karen interpreted the silence as victory. That was obvious. She continued, speaking faster now. "Your refusal to recognize my legal arguments constitutes abuse of authority." I said, "Disagreeing with an argument is not abuse of authority." She ignored me. Another warning sign. When someone stops responding to answers and continues delivering a speech, they are no longer participating in a conversation. They are performing. Karen flipped through several pages. "I have identified 14 procedural violations." Interesting, because earlier she claimed there were multiple violations. Now there were 14. Numbers that change during testimony usually tell a story, not a legal story. A psychological one. The story of someone constructing an argument as they go. Then she pointed directly at me. "Your conduct today has created probable cause." Probable cause. Another legal phrase. Another misuse. Michael's attorney finally stood and said, "Your Honor, can we please return to the actual dispute?" a reasonable request, but Karen had already built momentum in her own mind, and momentum can be dangerous, especially when someone mistakes confidence for authority. I looked at Karen. Mrs. Whitmore, this hearing concerns a contract dispute. If you have evidence relevant to the case, present it. That should have ended the matter. Instead, it escalated it. Karen suddenly closed her binder. Slowly, deliberately. Then she looked around the courtroom at the gallery, at the attorneys, at the bailiff, and finally at me. I recognized that look immediately. Years on the bench teach you to watch body language as carefully as words, because sometimes a person's next action arrives on their face before it arrives in reality. Karen believed she was about to do something historic. That much was obvious. Then she stepped away from her table. Without permission, the bailiff straightened slightly. Not alarmed adult. Karen walked forward one step, then another. The room became silent. I said, "Mrs. Whitmore, return to your position." She ignored me. That was the second warning. Ignoring instructions from the bench is never wise. Ignoring repeated instructions is often the moment consequences begin. Karen stopped a few feet from the bench. Then she unfolded the document dramatically. I am acting under citizen authority. The phrase itself was meaningless in that context, but Karen clearly believed it wasn't. I could see it in her eyes. She thought she had discovered a legal shortcut, a hidden rule, a secret power. Then she pointed directly at me and said the sentence nobody in that courtroom expected to hear. "Judge Judy, I am placing you under citizen's arrest." For one full second, nobody moved, not because they agreed, because they genuinely couldn't believe what they had just heard. And then everything changed. For 1 second, after Karen Whitmore announced my citizen's arrest, the courtroom stopped breathing. That is the only way I can describe it. The attorneys froze. The spectators stared. Even the court reporter paused before resuming her work. It was not shock alone. It was confusion. Because everyone was trying to understand whether they had actually heard what they thought they heard. Karen, however, looked triumphant. That was what struck me most. She genuinely believed she had just taken control of the courtroom. Years on the bench teach you that reality and confidence are not always connected. Sometimes the least informed person in the room is the most certain. I looked at her calmly. "Mrs. Whitmore, return to your table immediately." She shook her head. "No." The bailiff took one step forward. Not aggressively, professionally, Karen noticed, and instead of becoming cautious, she became louder. That was her mistake. She raised the document higher. "I am exercising my rights as a citizen." Again, the same pattern. When facts failed, Karen retreated into legal phrases she barely understood. I said, "Mrs. Whitmore, this proceeding is not about me. Return to your position." She pointed at me. "You are refusing a lawful arrest." The gallery reacted. Several people looked down to hide their expressions. Others simply stared. Michael Turner looked like a man who could not believe his simple patio dispute had somehow transformed into this. And honestly, I understood how he felt, because the entire hearing had drifted far beyond the original contract. Karen was no longer defending herself. She was trying to become the story. That is an important distinction. Attention can become addictive. Some people stop caring whether they are right. They only care whether everyone is looking at them. Karen had reached that point. Then she took another step toward the bench. That changed everything. Not because she was threatening. Because she was refusing lawful courtroom instructions, the bailiff moved immediately. Egan, professionally, Egan, calmly. "Ma'am, return to your table." Karen ignored him. "Strike one." "Ma'am, step back." Ignored. "Strike two." Then Karen did something that made the entire room tense. She extended the document toward me as though serving an arrest warrant. There was no warrant, no authority, no legal basis, just paper. But in Karen's mind, that paper had become power. The bailiff intercepted her before she reached the bench. Corin pulled her arm back, not violently, but enough to force intervention. The gallery gasped, and then the courtroom transformed from a hearing into a courtroom security incident. A second bailiff entered. Karen began speaking rapidly. "You can't touch me. You work for me. This is an unlawful detention." The phrases poured out one after another, not argument scripts, things she had memorized somewhere and now repeated under pressure. I watched quietly because there is a lesson every judge eventually learns. You cannot argue someone back into reality once they have chosen performance over reason. You can only apply procedure. The bailiffs instructed Karen to stop resisting. She refused, again. And that refusal lasted exactly long enough for the situation to become much worse. Because while Karen was shouting about rights, Michael's attorney quietly handed something to the clerk, a document. One that had absolutely nothing to do with citizens' arrests and everything to do with why Karen was really trying to derail the hearing. The moment I saw it, I understood exactly what she was hiding, and suddenly her behavior made perfect sense. While Karen Whitmore argued with the bailiffs, my attention shifted to the document Michael Turner's attorney had just handed to the clerk. I reviewed it carefully, and within seconds, the entire morning finally made sense, the contract dispute. The delays, the constitutional speeches, the accusations, the attempted citizen's arrest, all of it, not random, not confusion, strategy. The document was a financing application Karen had submitted months earlier while seeking a home equity loan. On that application, she listed the patio renovation as a completed improvement, not planned, not disputed gum-peeped. The value increase she claimed from the renovation was substantial. And more importantly, she specifically described the work as professionally performed. The courtroom became quiet again as I examined the records. Karen was still arguing with the bailiffs, still insisting she was the victim, still claiming unlawful detention. But the truth had quietly entered the room while she was distracted by her own performance. I asked Karen to return to her seat. Eventually, after several instructions, she complied. Her face was red with anger, her breathing was heavy, and for the first time all day, she looked uncertain, because she sensed something had changed. I held up the financing application. Mrs. Whitmore, is this your signature? Her eyes widened, only slightly, but I saw it. Yes. Did you submit this document? Yes. Did you state that Mr. Turner's patio renovation increased the value of your property? Silence. The gallery leaned forward. Michael stared at Karen. Karen looked at the table. Then she said, "That's irrelevant." There it was. The answer people give when relevance becomes dangerous, I continued. You told this court the work was fraudulent. No response. You told your lender the work was professionally completed. Still no response. You requested additional financing based partly on the increased property value created by that same work. The room became absolutely silent. Then Michael's attorney presented another document, a real estate listing draft, prepared by Karen, never publicly posted, but saved through her realtor's records. The listing highlighted the renovated patio as one of the home's premium selling features. The exact patio she now claimed was defective. A low murmur spread through the gallery. Karen looked trapped, because she was not by the court. By her own statements, months earlier, when she wanted financing, the patio was excellent. When she wanted increased property value, the patio was excellent. When she wanted to avoid paying the contractor, suddenly the patio became fraud. That contradiction destroyed her entire case. I looked directly at her. Mrs. Whitmore, were you attempting to benefit from this work while refusing to pay for it? Her mouth opened, closed, opened again. Nothing, no legal phrases. No constitutional arguments, no citizen's arrest, nothing. Then came the moment everyone remembered. Karen suddenly stood up again. The bailiffs immediately moved closer. She pointed toward me and shouted, "This is exactly why I arrested you." The courtroom erupted, not because the statement was powerful, because it revealed everything. She had never attempted that ridiculous arrest because she believed in the law. She attempted it because the evidence was destroying her. And now everyone could see it. Every person in that room, every spectator, every attorney, every court officer, even Karen herself. The performance was over. Only the truth remained. And the truth was devastating. After Karen Whitmore shouted, "This is exactly why I arrested you," the courtroom finally saw the entire picture. Not the version Karen wanted people to see, the real one. A contractor completed a project. The homeowner praised it, used it to increase property value, used it to support financing applications, used it as a selling point, and then refused to pay the man who performed the work. Everything else had been noise. The constitutional speeches, the accusations, the binder, the citizen's arrest. The attacks on the court, all of it was smoke designed to distract from one simple fact. Karen owed Michael Turner money, and she knew it. I looked at Karen for a long moment. Years on the bench teach you that some cases are about evidence. Others are about human nature. This one was both, because Karen had convinced herself that if she created enough chaos, accountability would lose interest. But accountability does not get distracted. It waits patently for the noise to stop. Then it speaks. I ruled in Michael Turner's favor. The signed contracts were valid. The approved change orders were valid. The invoices were valid. The evidence overwhelmingly established that the work had been completed, accepted, praised, and financially leveraged by Karen herself. Judgment was entered for the unpaid balance, court costs, and related damages permitted under the law. Karen stared at me. You're protecting him. I shook my head. No, Mrs. Whitmore. The evidence protected him. The gallery remained silent because everyone knew that was true. Michael sat back in his chair. For the first time all day, the tension left his face. Not because he was celebrating. Because he was finally finished fighting. There is a difference. People often assume winning in court feels exciting. Usually it feels like relief. Relief that the truth finally caught up. Relief that documentation mattered. Relief that someone listened. Karen gathered her binder slowly. The same binder she had carried into court with such confidence. The same binder she believed would help her dominate the room. Now it looked heavy, not physically, emotionally. Because every page inside represented a strategy that had failed. As she prepared to leave, I gave one final observation for the record. Rights are important. Legal procedure is important. But neither exists to help people escape obligations they voluntarily accepted. Karen said nothing, for once. No speeches, no accusations, no citizen's arrest, nothing. The silence was remarkable. Then she walked out. The gallery watched her leave. The bailiffs relaxed. Michael collected his paperwork. And the courtroom slowly returned to normal. But that case stayed with me, not because someone attempted a citizen's arrest on a judge. As strange as that sounds, that was never the most important part. The important part was what caused it. Fear, not fear of injustice, fear of evidence, fear of accountability, fear of a truth too obvious to deny. Karen thought she could overpower facts with confidence. She thought she could replace evidence with performance. She thought she could put the judge on trial instead of herself. But courts do not function on volume. They function on proof. And when the proof finally arrived, her entire strategy collapsed in seconds. That is the lesson I still remember. The loudest person in the room often believes they control the story. But in a courtroom, the story belongs to the evidence. And on that day, the evidence spoke louder than Karen ever could.